Good morning, Reverend Griffin. This is M.L. Curry with my 15 minutes on workers' compensation. I'd like to start out the program with information about my sponsors. The first sponsor is Total Healthcare Management. They have 4 locations throughout the city at 934 East Tidwell, 11,000 Chimney Rock, 45 South in College, and their principal offices are at 12,000 Richmond. Their phone number for all of the locations is 713-522-6911. One of the things that I haven't mentioned about Total Healthcare Management over the last month or so is that they provide transportation for the patients to and from their doctor visits. Now, this is within the Highway 6 in the Houston metropolitan area. So for all of my clients who live out in Willis and New Caney and places like that, if you would just come into Highway 6, then Total Healthcare Management will be making arrangements for you to be able to get to the nearest location so that you can get the treatment that you need for your injury due to your accident. The other sponsor is Memorial MRI. Their offices are at 1241 Campbell here in Houston and at 1346 Campbell. They do the open MRI, they do CT scans, echocardiograms, and EMGs. And one of the more important things that they do as far as the MRI is concerned is that they give the exact measurements that I need to be able to prove an extent issue on your case. A lot of times people's injuries and accidents involve claims that are denied by the insurance carrier, and one of the major injury portions that they deny is on extent questions. In other words, you may have an injury like we were talking about with Dr. Jackson last week, where you've injured your knee, and the insurance carrier will accept a knee strain. But then after you get the MRI over at Memorial MRI, you find that you have a torn medial meniscus. Well, then they deny that. Well, the measurements and how that particular tear occurred is going to be an issue that's going to help you to either win your case, help me to win your case once we have to take you to a BRC or to a CCH. We also are going to want to have an orthopedic referral to get his opinion as to how this particular tear occurred, and this will be consistent with the facts that you've given me when you first come into my office. We make sure that we get clear, concise facts from you when you come in, so when you call my office, or if you do like some people do, you can do your profile online. And if you will access my website at www.attymlcurry.net, you can actually access the website and click on profile, and then you can give a profile of your claim. You basically tell me how your accident occurred, what you were doing, who you were working for, and things like that. And then we can get an idea of which facility to have you referred to, as well as the type of treatment that you're going to need, whether it's going to be chiropractic, physical therapy, whether it's going to be orthopedic, neurosurgeon, or things like that. Last week we talked about making your doctor choice after you have gone to see the emergency room and after you have gone to the company doctor. You still have the right to choose your own doctor, and we hope that you choose the doctors over at Total Healthcare Management, which you can do also by calling through my office, and my number is 713-222-2400. A lot of people are not aware of the fact that just because you've gone to see the company doctor, that does not mean that you have to stay with the company doctor. Now, one of the things that happens very frequently is that people wait a little too long and work with the company doctor much too long because they think that working with the company doctor is going to help them to preserve their job. And this is just not true. The company, if they are going to terminate you, they're going to terminate you anyway. And you're staying with the company doctor, you're only compromising your claim because you're compromising the evidence that's going to be needed to help prove your claim after the insurance company denies your claim based on an extent issue. Like we indicated, they may ask for an MRI to be done, or they may not ask for an MRI to be done. But you have a 60-day time limit from the very first day that you go to the company doctor after your accident. 60 days from there, if you have not changed to your own doctor, you will then need the company doctor's permission to change doctors. And we have found that company doctors just will not give you permission to go to another doctor because they know that you're going to try to get the evidence that's going to be required that they are not giving you by having you to go out to get the issues resolved as far as what is actually wrong with you and why after 30 or 40 days you have not been able to return to work. And you're going to need the diagnostic test. Well, if your doctor doesn't recommend the diagnostic test, you will not be getting them. And if you don't get this done under the 60 days, then you're really compromising your own claim. I realize that a lot of times the injured worker is not the individual who's actually reviewing this program on the radio or reviewing the program on the website. A lot of times the person who's listening to this program, it may be someone who is a coworker of yours, or it may be someone who's a relative of yours, or a friend or a neighbor, someone that you see who's having a problem with workers' compensation. It may be one of your church members. You need to get with that person and give them my information. Have them to call me at 713-222-2400, or if they don't feel like they need to be represented right away, which is something that's going to happen later on down the road anyway, they may want to call 713-522-6911 and at least get their treatment together so that they're being treated by competent physicians who are interested in making the person well so that they can get back to work. Last week we talked with Dr. Jackson, and he indicated a number of different modalities and treatments that they give at his facility over at 45 South in College. And he indicated that sometimes a person may not be able to get back to work right away, and sometimes they have to go through different measures of conservative care that will help them to get back on the job. Sometimes that's just not possible, and the person's going to need to be off a little bit longer. During this program, we also have live calls that we take from time to time, so we're going to have that one screened, and I'll see if it's something that I need to respond to right away. Otherwise, if you call my office and you do get one of my secretaries, they will take your information down, and then I'll get in touch with you in between 5 and 7 in the evening. That's the time that I call my clients back, because I find that most people are at home in between 5 and 7 in the evening. Once the producer has a chance to screen that particular call, I'll see what it is. I may need to speak with that person during the program, or I may speak with you after the program. Now, today's topic is actually about how to put your adjuster in check. There are a number of people allow the adjusters for the insurance carrier to get away with a lot of activity that they really don't have to put up with. And that type of activity is very frustrating to an individual. What you need to do is to understand that there are rules that the adjuster has to follow. There are rules that the attorneys have to follow. The claimant has rules that he or she has to follow. And all these rules are codified within the Labor Code or the Texas Administrative Code or the Texas Register. Today I'm actually referring to what's called evidence of a pattern of conduct, and this is Rule 180.6. 180.6 has subdivisions, and it requires that you have at least 3 violations of the same rule, or the insurance carrier continues to violate rules after the commission has issued a written warning to them. Once you have found out that they are actually violating the rules, then you're able to file a complaint with the Resolution and Oversight Department of the Texas Department of Insurance, Division of Workers' Compensation. This used to be called Compliance and Practices. So they've changed the name. They've changed the names of different departments very frequently, almost as frequently as they change the rules. And I've indicated to you before that the rules change every June, and then they go into effect as of September 1st. You get a grace period of about 6 weeks, and then they don't take any further excuses after that. One of the violations that are very frequent comes under the Labor Code, Section 415.002, and that is if the insurance carrier stops your benefits and they don't have any evidence or any reason for being able to stop your benefits, or they pay your benefits at 2 or 3 different rates, and they don't even have a wage statement. Now, the wage statement is the DWC-3, and this is a document that's supposed to be filled out by your employer, and that is copies of your wages that have been calculated 90 days before your date of accident. The DWC-3 is a required document. So if you're one of these individuals who 1 week your workers' comp check is $500 and next week it's $200 and then the week after that it's $300, it's not supposed to be like that. Your workers' compensation check, your benefit check is supposed to be the same amount every week. It is also supposed to come on the same day of the week. So if you have an adjuster who's just refusing or just thinking that it's okay for you to receive your check on Wednesday this week or Friday of next week, and you have bills to pay just like everybody else, you have a right to have your benefit check received at your house from week to week on the same day of the week. And it should also be for the correct amount. You can calculate how that amount is, what that amount should be by getting your own check stubs and just adding them up for the 13 weeks before your date of accident. This becomes a little dicey sometimes because some people are paid by the week and other people are paid by bi-weekly. But if you are paid weekly, then you're to go back 13 weeks. If you're paid bi-weekly, you're to go back 14 weeks. Either way, once you add up all your benefits and then you divide it by the number of weeks. So if you're on a bi-weekly, you're divided by 14. If you're on weekly, you're divided by 13. Some people have the problem of not having worked a full 90 days before their date of accident. This happens very frequently. Sometimes a person may only have worked one day before their accident, and sometimes any number of days up to 13 weeks. Under circumstances like this, the individual is supposed to have his wages calculated not by his own wages, but by the wages of a same and similar employee. This is someone who does the same job that you were doing or a similar job that you were doing at the same company where you worked, and that person worked for 13 full weeks. So you can see that although you may have only worked there for 5 or 6 weeks, your actual workers' compensation check would be higher if it's based upon one of your coworkers who's worked there for the full 13 weeks. And if the insurance company is just refusing to pay you the correct amount that you calculated, then this is a reason for you to go to a benefit review conference and prove this. Now, you may not want to do that because once you go to a benefit review conference and you agree, you cannot come back later and then change it after you've come to my office and I find that you actually settled for an amount that was less than the amount that you should have received. So you may want to hold on that particular issue and contact my office at 713-222-2400. Got another call coming through. Okay. One of the other issues is failure to confirm medical benefits. When the insurance carrier contacts you, they contact you by a PLN form. And on that form, they should be telling you that you have medical benefits and that you have indemnity benefits. And if they're telling you anything or even failing to start your benefits and they don't have a legitimate reason as far as liability is concerned, you've had an accident, you know, there are witnesses, you reported it properly, and then just for some reason they just stop paying your benefits and they haven't given you a reason for that. All these are violations that I'm talking about when I first started out that indicate evidence of a pattern of conduct, and that is Rule 180.6. So once you have called the adjuster on 2 or 3 violations, then you're able to file a complaint with the Texas Department of Insurance, the Division of Workers' Compensation. Their offices principally are in Austin, but there are 3 offices here in Houston at the 5400 Polk and out in Missouri City on Texas Parkway, and then there's one out at Greens Point, 45 North in the Beltway 8. I'm just about out of time, and you know I like to indicate to my people that Hebrews 1:11, now faith is the substance of things hoped for and evidence of things not seen. That's my favorite because, of course, it involves the legal aspect of religion and dealing with how you are to have faith in what I'm doing as well as to seek the help that you need. So I want to ask Reverend Griffin to start his closeout music just before he starts his feedback corner program, and contact my office at 713-222-2400 and contact Total Healthcare Management at 713-522-6911. I'd like to close out by saying God bless you and hope that you will make the right decisions and not wait too long, because, you know, sometimes people wait way too long and I'm not able to help you. I had a couple of people come in this week that I had to turn away because they compromised their claims so very badly that even I could not help them. So give yourself a chance and make the right call. Thank you so very much. God bless you. Bye-bye.